LiberalViewer presents.
So, welcome to this special LiberalViewer live stream covering the third January 6th committee public hearing yesterday. I'm Alan Ash, political junkie and longtime YouTuber, and also I'm a lawyer, and I'll be using my training and experience to add my commentary and criticism to a bunch of clips from yesterday, raising the big question in my video title about whether Donald Trump and his attorney John Eastman criminally conspired to pressure Vice President Mike Pence to overthrow U.S. democracy. Also, for fans of my cat Dash, I'll be showing a final Dash clip at the end of the live stream and talking about how he passed away yesterday, which this is a tough live stream to do, honestly, but anyway, because I'm a former criminal defense attorney, I will be committing some legal analysis about whether this attorney advising President Trump, John Eastman, committed a federal crime, and whether President Trump himself committed a federal crime when they pressured Vice President Mike Pence to illegally reject electoral votes or send them back to the states on January 6th. Specifically, I will be talking to you again about 18 U.S.C. sub C sub 2, which for my regular viewers know that this is making it a felony to corruptly obstruct an official proceeding. And courts have already found that the certification of the vote on January 6th qualifies as an official proceeding, and this is a crime that's a felony punishable by up to 20 years in prison. So corruptly obstructing the January 6th certification of the votes is a felony that has a punishment of up to 20 years in prison. And the big question is about the word corruptly, again, as it has been in previous live streams, because that's the intent, that's the criminal intent that you have to show that President Trump or John Eastman had to commit this crime here. And so that's the big question about the word corruptly. Did Trump and his lawyer John Eastman know what they were asking Mike Pence to do was illegal? And then, as I'll show with these 9 clips coming up, there was a lot of evidence presented yesterday that John Eastman, the lawyer, knew what he was doing was illegal, and there was some evidence that Trump knew it too. There was also a lot of evidence of the pressure that Trump put on Mike Pence to illegally reject electoral votes. He sent that crowd to the Capitol chanting "Hang Mike Pence," and continued to tweet criticism of Mike Pence even when he knew that Pence was in danger. And I put a link down in the video description to the entire hearing because I'm not really covering the part about the rioters marching on the Capitol and putting Mike Pence in danger so much. But you can see the whole hearing if you want on the C-SPAN channel on YouTube for free. I'll be focusing more on the illegality of trying to get the idea of getting the Vice President Mike Pence to reject votes. But I do want to start off with a little political comedy about Trump's pressure on Mike Pence when Representative Pete Aguilar on the January 6th committee, he didn't have witnesses for this, so he just recounted a January 5th conversation between President Donald Trump and Vice President Mike Pence that actually comes from the Bob Woodward, Robert Costa book Peril, which I will talk about with you a little more after we watch that clip together over here.
In the book Peril, journalists Bob Woodward and Robert Costa write that the president said, quote, "If these people say you have the power, wouldn't you want to?" The vice president says, quote, "I wouldn't want any one person to have that authority." The president responds, "But wouldn't it almost be cool to have that power?" The vice president is reported to have said, "No, look, I've read this, and I don't see a way to do it. We've exhausted every option. I've done everything I could, and then some, to find a way around this. It's simply not possible. My interpretation is no." To which the president says, no, no, no. You don't understand, Mike. You can do this. I don't want to be your friend anymore if you don't do this.
I mean, what is Donald Trump, like a 6-year-old? Is that like, that's kind of the threat you think of, like kindergarten, first grade level threat? Like, if you don't do this, I won't be your friend anymore. I don't know, maybe somewhere later in elementary school. I guess it depends on the social maturity, but that was pretty ridiculous. Like I said, I'm not focusing so much on the pressure on Mike Pence as I am on the illegality of the scheme. And I'm going to show you multiple clips, mostly from Greg Jacob, who was counsel to Vice President Pence. I will also have at least one. There's one clip coming up of this conservative judge, Michael Ludig, who is this like conservative legend, and who John Eastman clerked for, and I think maybe Greg Jacob clerked for. I know John Eastman clerked for Michael Ludig, who totally disagrees with this attorney, John Eastman, who advised President Trump that he could get the vice president to change the outcome of the 2020 election. It's ridiculous. And I'm going to show you multiple clips on this, but for one criticism I have of all the exhibits that the January 6th committee showed, one thing they didn't show was the 12th Amendment to the Constitution. Down in the video description, I put a link to the 12th Amendment. I've also put a link to the federal statute that is the codification of the Electoral Count Act that they'll be talking about. That's 3 U.S.C. Section 15, counting electoral votes in Congress. That is kind of hard for a layman to read, but so I'm not really saying that they should have shown that, though I will show it to you in a minute. But here's the 12th Amendment. Oh, by the way, if you have your, I send these ACLU constitutions out to my monthly patrons on Patreon if they pledge at least $5 a month, or even if you give a direct contribution of $5 on PayPal. There's a link under the video for that. I send out the Constitution and this weatherproof vinyl #LiberalViewer sticker. And if you happen to have your copy of the Constitution, you can look at the 12th Amendment yourself, but I will show you a copy of the 12th Amendment, which is kind of long and involved, but I've highlighted this part about the President of the Senate. Now, you should know the Vice President of the United States is the President of the Senate for that's all the time. That's why, like, if there's a 50-50 Senate, the Vice President breaks ties because the Vice President is the President of the Senate. So this is what the 12th Amendment says about what to do when it's time to count the votes. It says, the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. Does not give the Vice President any discretion, any investigatory powers, any discretion to decide what votes to count or what votes not to count. Now, you can read through the Electoral Count Act here, which, like I said, is 3 U.S.C. Section 15, and it's really long and involved, but it also does not give the Vice President any role in objecting to votes or investigating votes or sending votes back. And the thing is, it's like, if it's not only about reading the text of the Constitution and looking at that particular phrase in the 12th Amendment, it's really understanding what is the Constitution all about. What is our democratic republic? I know conservatives like to say it's not a democracy, it's a republic. Well, it's a democratic republic. That means the people have the power to elect their representatives to create a government that is limited in scope by the rights that the people and the states retain. That's what a democratic republic is. And what is totally anathema to a democratic republic? The idea that one guy, the vice president, every 4 years gets to decide, oh, we're going to throw out the votes of the people to, elect the electors who elect the president. We're going to throw all that out and just give this one guy who probably has an interest in the outcome himself, we're going to give him the power to decide. Do you think that is what the Constitution's all about? That is ridiculous, and you'll hear Greg Jacob explain why the text of the Constitution, the structure of the Constitution that I was just talking about, and the history of the Constitution all say that that is a ridiculous idea. In this second clip from the hearing, I will talk about with you a little more after we watch it together over here.
So, you, as a lawyer who's analyzing a constitutional provision, you start with the constitutional text, you go to structure, you go to history. So we started with the text. We did not think that the text was quite as unambiguous as Judge Ludig indicated. In part, we had a constitutional crisis in 1876 because in that year, multiple slates of electors were certified by multiple slates. And when it came time to count those votes, the antecedent question of which ones had to be answered. That required the appointment of an independent commission. That commission had to resolve that question, and the purpose of the Electoral Count Act of 1887 had been to resolve those latent ambiguities. Now, I'm in complete agreement with Judge Ludig. It is unambiguous that the vice president does not have the authority to reject electors. There is no suggestion of any kind that it does. There is no mention of rejecting or objecting to electors anywhere in the 12th Amendment. And so the notion that the vice president could do that certainly is not in the text. But the problem that we had and that John Eastman raised in our discussions was we had all seen that in Congress in 2000, in 2004, in 2016, there had been objections raised to various states. And those had even been debated in 2004. And so here you have an amendment that says nothing about objecting or rejecting, and yet we did have some recent practice of that happening within the terms of the Electoral Count Act. So we started with that text, and I recall in my discussion with the vice president, he said, I can't wait to go to heaven and meet the framers and tell them the work that you did in putting together our Constitution is a work of genius. Thank you. It was divinely inspired. There is one sentence that I would like to talk to you a little bit about. So then we went to structure. And again, the vice president's first instinct here is so decisive on this question. There's just no way that the framers of the Constitution, who divided power and authority, who separated it out, who had broken away from George III and declared him to be a tyrant, there was no way that they would have put in the hands of one person the authority to determine who was going to be president of the United States. And then we went to history. We examined every single electoral vote count that had happened in Congress since the beginning of the country. We examined the Electoral Count Act. We examined practice under the Electoral Count Act. And critically, no vice president in 230 years of history had ever claimed to have that kind of authority, hadn't claimed authority to reject electoral votes, had not claimed authority to return electoral votes back to the states. In the entire history of the United States, not once had a joint session ever returned electoral votes back to the states to be counted. And in the crisis of 1876, Justice Bradley of the United States Supreme Court, who supplied the decisive final vote on that commission, had specifically looked at that question and said, first, the vice president clearly doesn't have authority to decide anything, and by the way, also does not have authority to conduct an investigation by sending things back out for a public look at things. So the history was absolutely decisive. And again, part of my discussion with Mr. Eastman was, if you were right, don't you think Al Gore might have liked to have known in 2000 that he had authority to just declare himself president of the United States? Did you think that the Democrat lawyers just didn't think of this very obvious quirk that he could use to do that? And of course, he acknowledged Al Gore did not and should not have had that authority at that point in time. But so text, structure, history, I think what we had was some ambiguous text that common sense and structure would tell you the answer cannot possibly be that the vice president has that authority. As the committee already played the vice president's remarks, there is almost no idea more un-American than the notion that any one person would choose the American president. And then unbroken historical practice for 230 years that the vice president did not have such an authority.
So in terms of this legal theory being bogus, Greg Jacob, the former counsel to Vice President Mike Pence there, laid it out that the text of the 12th Amendment that I showed you earlier, it doesn't give the Vice President any discretion. The Electoral Count Act, which is codified at 3 U.S.C. Section 15, and I have both the 12th Amendment and 3 U.S.C. Section 15. There are links down in the video description. You can read them yourself, and there's like nothing in there that gives the Vice President the authority to reject electoral votes or to like send them back to the states for investigation, which is what John Eastman was trying to get Mike Pence to do, and was conspiring. You know, he was working with Donald Trump to get this accomplished, and he knew it was illegal, and he told Donald Trump it was illegal, as I'll show with the rest of the clips. But most of the clips I'm showing of the witnesses testifying are of Greg Jacob, who I thought was a really good witness. The other witness, this like revered conservative judge, Michael Ludig, I thought he was not a great witness, and a lot of people were commenting on it, and then I saw that people were saying he recently had a stroke, which is why he kind of speaks slowly, which, you know, I'm not going to hold that against him, but he also really didn't answer the questions very well. I mean, he just didn't make a good witness, regardless of how slowly he was speaking, and I'm going to show one clip of him answering a question about how his former law clerk, this is retired conservative judge Michael Ludig talking about his former law clerk John Eastman, this lawyer who was working with President Trump to pressure Mike Pence into overthrowing our entire U.S. democracy. So here you'll see the Representative Pete Aguilar, on the January 6th committee, ask him about this smoking gun evidence. Here's like this smoking gun evidence that in a memo that, or in a letter to the President of the United States that John Eastman worked on back in October 2020, the month before the election, he put these things in blue here where he realized, or he admitted that his whole theory that the vice president has the ability to reject electoral votes is bogus. He said that right here in this draft letter to the President of the United States back in October 2020, and Representative Pete Aguilar asks conservative or retired conservative judge Michael Ludig about it, and he like totally goes off on this whole other tangent, and he says he is surprised, and then I don't like the rest of his answer that I will talk about with you a little more after we watch it together over here.
In our investigation, the Select Committee has obtained evidence suggesting that Dr. Eastman never really believed his own theory. Let me explain. On the screen, you can see a draft letter to the President from October 2020. In this letter, an idea was proposed that the Vice President could determine which electors to count at the joint session of Congress. But the person writing in blue eviscerates that argument. The person who wrote the comments in blue wrote, quote, "The 12th Amendment only says that the President of the Senate opens the ballots in the joint session, and then, in the passive voice, that the votes shall then be counted." The comments in blue further state, "Nowhere does it suggest that the President of the Senate gets to make the determination on his own." Judge Ludig, does it surprise you that the author of those comments in blue was in fact John Eastman?
Yes, it does, Congressman. But let me, watching this unfold, let me try to unpack what was at the root of what I have called the blueprint to overturn the 2020 election. And it is this, and I had foreshadowed this answer in my earlier testimony to Congresswoman Cheney. Mr. Eastman, from the beginning, said to the President that there was both legal as well as historical precedent for the Vice President to overturn the election. And what we've heard today, I believe, is what happened within the White House and elsewhere as all the players led by Mr. Eastman got wrapped around the axle by the historical evidence claim by Mr. Eastman. Let me explain very simply. This is what I said would require a digression that I would be glad to undertake if you wished. In short, if I had been advising the Vice President of the United States on January 6th, and even if then Vice President Jefferson and even then Vice President John Adams and even then Vice President Richard Nixon had done exactly what the President of the United States wanted his Vice President to do. I would have laid my body across the road before I would have let the Vice President overturn the 2020 election on the basis of that historical precedent. But what this body needs to know, and now America needs to know, is that that was the centerpiece of the plan to overturn the 2020 election. It was the historical precedent in the years and with the vice presidents that I named, as Congressman Raskin understands well. And the effort by Mr. Eastman and others was to drive that historical precedent up to and under that single sentence, single pristine sentence in the 12th Amendment to the United States Constitution. taking advantage of, if you will, what many have said is the inartful wording of that sentence in the 12th Amendment. Scholars before 2020 would have used that historical precedent to argue not that Vice President Pence could overturn the 2020 election by accepting non-certified state electoral votes, but they would have made arguments as to some substantive, not merely procedural, authority possessed by the Vice President of the United States on the statutorily prescribed day for counting the Electoral College votes. This is constitutional mischief.
Constitutional mischief. I mean, that's a good phrase. And he did have some insightful things to say during parts of his testimony. But he did speak slowly, which I'm not going to, like I say, hold against him given his recent stroke. But I also thought the insightful things he had to say rarely addressed the question. I thought there should have been a lot more focus on this October draft letter to POTUS that he was asked about, where you see John Eastman admitting to his constitutional mischief. Why, that was, I mean, if you were really trying to indict the illegality of what occurred on January 6th in terms of a legal interpretation of the 12th Amendment and the Electoral Count Act, you would focus on John Eastman, his consciousness of guilt that is shown here. But John Eastman's consciousness of guilt is also shown pretty clearly in the testimony of Greg Jacob, the counsel to the vice president. This next clip is the longest clip I'm going to show you. It's basically the whack-a-mole that Greg Jacob did with the whack-a-mole that Greg Jacob did with John Eastman. I don't know, why was I calling him Mark Eastman for a second? John Eastman, the lawyer who worked with the president, conspired with him to obstruct the official proceeding on January 6th. And here you can see Greg Jacob talking about multiple hours he spent arguing with John Eastman, and both about whether the vice president had the power to reject electoral votes or send them back to the states. And he, he was kind of confused. They did sort of a switcheroo on which of the two theories they were working on. But by the end of this clip, you'll see that both theories depend on the idea that even though there's nothing in the Constitution that gives the vice president what's called plenary authority, like where that means like the supreme power to decide who is president, that would have to be in the Constitution, that the vice president has this supreme original power to decide who is president of the United States based on what it says in the 12th Amendment. Based on what it says in the 12th Amendment. Remember, let's look at the 12th Amendment again. The vice president is the president of the Senate, and it says, this is the power it gives him. It says, in the presence of the Senate and House of Representatives, he has the power to open all the certificates, and then it moves to the passive voice and says, and the votes shall then be counted. So where does the vice president get this power? Nowhere. Nowhere. And Greg Jacob made that point pretty clearly to John Eastman in hours of conversation on January 5th, the day before January 6th, of course. And like I said, this is the longest clip, but it's worth watching. And I will talk about it with you a little more after we watch it together over here.
What most surprised me about that meeting was that when Mr. Eastman came in, he said, "I'm here to request that you reject the electors." So on the 4th, that had been the path that he had said, "I'm not recommending that you do that." But on the 5th, he came in and expressly requested that. And I grabbed a notebook as I was heading into the meeting. I didn't hear much new from him to record, but that was the first thing I recorded in my notes, was request that the VP reject.
Just to be clear, you're saying that Dr. Eastman urged the Vice President to adopt the very same approach that Dr. Eastman appeared to abandon in the Oval Office meeting with the President the day before. Is that correct?
He had recommended against it the evening before, and then on the 5th came in, and I think it was probably his first words after introductions and as we sat down were, "I'm here to request that you reject the electors in the disputed states."
And you referenced a moment ago some handwritten notes, which you've provided to the Select Committee. I'd now like to show you those notes. As you can see, you wrote there at the top, the writing's a little bit faint in the copy, but you wrote, "Requesting VP reject." Does that accurately reflect what Dr. Eastman asked of you in your meeting on January 5th?
Yes.
And what was your reaction when Dr. Eastman said on January 5th that he was there to ask the Vice President of the United States to reject electors at the joint session of Congress?
I was surprised because I had viewed it as sort of one of the key concessions that we had secured the night before from Mr. Eastman that he was not recommending that we do that.
So what did you say to him?
Well, as I indicated, to some extent it simplified my task because there are more procedural complexities to the send it back to the states point of view, and I actually had spent most of my evening the night before writing a memorandum to the Vice President explaining all of the specific provisions of the Electoral Count Act that plan would violate. So instead, since he was pushing the sort of robust unilateral power theory, I've already walked the committee through the discussions that we had. I started out with our points of commonality, or what I thought were our points of commonality. We're conservatives, we're small government people, we believe in originalism as the means by which we're going to interpret this. And so we walked through the text, we walked through the history, and the committee has shown footage of Mr. Eastman on the stage on the 6th claiming that Jefferson supported his position in a historical example of Jefferson. In fact, he conceded in that meeting Jefferson did not at all support his position, that in the election of 1800, there had been some small technical defect with the certificate in Georgia. It was absolutely undisputed that Jefferson had won Georgia. Jefferson did not assert that he had any authority to reject electors. He did not assert that he had any authority to resolve any issue during the course of that. And so he acknowledged by the end that there was no historical practice whatsoever that supported his position. He had initially tried to push examples of Jefferson and Adams. He ultimately acknowledged they did not work, as we've covered. He acknowledged it would lose 9-0 in the Supreme Court. He again tried to say, but I don't think the courts will get involved in this. They'll invoke the political question doctrine, and so if the courts stay out of it, that will mean that we'll have the 10 days for the states to weigh in and resolve it, and then they'll send back the Trump slates of electors, and the people will be able to accept that. And I expressed my vociferous disagreement with that point. I did not think that this was a political question. Among other things, if the courts did not step in to resolve this, there was nobody else to resolve it. You would be in a situation where you have a standoff between the President of the United States and, counterfactually, the Vice President of the United States, saying that we've exercised authorities that constitutionally we think we have, by which we have deemed ourselves the winners of the election. You would have an opposed House and Senate disagreeing with that. You would have state legislatures that, to that point, I mean, Republican leaders across those legislatures had put out statements, and we collected these for the vice president as well, that the people had spoken in their states and that they had no intention of reversing the outcome of the election. We did receive some signed letters that Mr. Eastman forwarded us by minorities of leaders in those states, but no state had any legislative house that indicated that it had any interest in it. So you would have had just an unprecedented constitutional jump ball situation with that standoff. And as I expressed to him, that issue might well then have to be decided in the streets. Because if we can't work it out politically, we've already seen how charged up people are about this election. And so it would be a disastrous situation to be in. So I said, I think the courts will intervene. I do not see a commitment in the Constitution of the question whether the vice president has that authority to some other actor to resolve. There's arguments about whether Congress and the vice president jointly have a constitutional commitment to generally decide electoral vote issues. I don't think that they have any authority to object or reject them. I don't see it in the 12th Amendment, but nonetheless. And I concluded by saying, John, in light of everything that we've discussed, can't we just both agree that this is a terrible idea? And he couldn't quite bring himself to say yes to that, but he very clearly said, well, yeah, I see we're not going to be able to persuade you to do this. And that was how the meeting concluded.
But you just described a terrifying scenario. Sounds like there could have been chaos under the Eastman approach, and you even described it as it potentially could be decided in the streets. And you described several concessions that Dr. Eastman made throughout that discussion or even debate that you had with him. At some point during that meeting on January 5th, did Dr. Eastman seem to admit that both of the theories that he had presented to the United States the day before? So the theory that the vice president could reject electors outright and declare Donald Trump the winner, and his less aggressive theory that the vice president could simply send it back to the states. At some point in that conversation on the 5th, did Dr. Eastman seem to admit that both of these theories suffered from similar legal flaws?
So I had at least one, possibly two other conversations with Dr. Eastman later that day. In the earlier meeting, we really were focused, because his request that he made had been reject the electors outright, on why that theory was wrong and why we certainly would not be doing that. Later that day, he pivoted back to, well, we hear you loud and clear, you're not going to reject. But remember last night, I said that there was this more prudent course where you could just send it back to the states. Would you be willing to do that? And during the course of our discussion about his renewed request that we consider that option, he acknowledged to me, he put it, both Mr. Eastman and myself are graduates of the University of Chicago Law School, and he said, look, as graduates of that august institution, you and I will mutually understand that the underlying legal theory of plenary vice presidential authority is what you have to get there. Because this new theory, as I was pointing out to him, or the procedural theory, still violates several provisions of the Electoral Count Act, as he acknowledged. And the only way that you could ever be able to ignore several provisions of statutory law is if it was pretty clear that they were unconstitutional. And the only way they could be unconstitutional is if the vice president had the plenary authorities that were formed the basis for the reject the votes as well. So he acknowledged in those conversations that the underlying legal theory was the same. He just thought that the send it back to the states option would be more politically palatable, and he hoped more palatable to the vice president for that reason.
And in fact, when Dr. Eastman made this concession during that meeting, according to your earlier deposition, Dr. Eastman said, just between us, University of Chicago chickens, is that right?
I don't think that the University of Chicago is going to start a Chicago Chickens fundraising club, but yes, that is the terminology that he used. He said, you know, just between us Chicago chickens, we will understand as lawyers who have studied the Constitution that the underlying basis really is the same.
So yeah, when it's nobody here but us chickens, we know we're committing a felony, is basically the felony of violating 18 U.S.C. 1512 sub C sub 2, corruptly obstructing an official proceeding, the certification of the votes on January 6th. That was like the long version of the whack-a-mole game that Greg Jacob played when he was trying to convince John Eastman that it was totally illegal to have the vice president either reject electoral votes or send it back to the states. That's the whack-a-mole game. Like, they kept changing their argument. But what he's saying is the only way that you could violate the Electoral Count Act, that's, like I said, codified over in 3 U.S.C. Section 15, counting electoral votes in Congress, to have the vice president decide which votes to count or send it back to the states, either theory violates the Electoral Count Act, and you can only violate the Electoral Count Act if you think that the vice president has plenary authority to decide what happens in the elections. The only place he could get that is from the 12th Amendment, which I showed you, the 12th Amendment, which I showed you earlier, where the only power he gets is to, in the presence of the Senate and House of Representatives, open all the certificates, and the vote shall then be counted. So, no, he doesn't get that plenary authority in the 12th Amendment or anywhere else. Can anyone show me where the vice president in the Constitution here gets the authority to decide which electoral votes to count? It's not in there. And so John Eastman admitted that he's violating federal law, the Electoral Count Act, because it's unconstitutional, but he has no reason it's unconstitutional. So all of us chickens who went to law school will understand that he's committing a felony. That's basically what was going on in that testimony. But that was kind of like the long lawyer version. There were a couple things in there that I thought were there's like the short version that I think the sound bites that for non-lawyers make it even more clear, although some of it was even in that last clip. But the first one I want to show you is Greg Jacobs later in the hearing talking about how he had, as part of that same January 5th discussion he had with John Eastman, he got John Eastman to admit, well, Mike Pence, if you want Mike Pence to have this authority to decide who's president, does that mean back in 2000 that Al Gore should have decided that he won in 2000? How come he didn't have that power? Or in 2025, January 6, 2025, you want Kamala Harris to decide? And this is where you see the corruptness. Like, this is totally corrupt. If you want to show how John Eastman at least has a corrupt purpose in violating 18 U.S.C. 1512 sub C sub 2, he's corruptly obstructing this official proceeding because he doesn't really believe a vice president has this power. He just wants to do it on January 6th, as you will see over in this clip.
Did Dr. Eastman say whether he would want other vice presidents, such as Al Gore, after the 2000 election, or Kamala Harris after the 2024 election, to have the power to decide the outcome of the election?
So this was one of the many points that we discussed on January 5th. He had come into that meeting trying to persuade us that there was some validity to his theory. I viewed it as my objective to persuade him to acknowledge he was just wrong. And I thought this had to be one of the most powerful arguments. I mean, John, back in 2000, you weren't jumping up and saying Al Gore had this authority to do that. You would not want Kamala Harris to be able to exercise that kind of authority in 2024 when I hope Republicans will win the election, and I know you hope that too, John. And he said, absolutely. Al Gore did not have a basis to do it in 2000. Kamala Harris shouldn't be able to do it in 2024, but I think you should do it today.
So, yeah, that is a pretty simple to understand explanation of how John Eastman had a corrupt intent, because he didn't really believe in the power of the vice president to reject electoral votes, because he didn't think Al Gore had that power. He didn't want Kamala Harris to have that power. He just wanted that day for Mike Pence to exercise a constitutional power that does not exist to overturn the lawful election of Joe Biden in 2020. Now, the other argument that I think this is like less than a minute, if you wanted like a 45-second, well, I guess it's 47-second clip that shows that John Eastman knew his legal argument was bogus, bullshit, whatever, ridiculous. Here's where they were talking, and what's funny is this is where he admits that he's going to lose. If he made this argument in the Supreme Court, he would lose it 9-0. And I think that was mentioned in the long explanation from Greg Jacob a couple clips back. But he also talked about how he thought it might be a political question, and that was what was really disturbing, because if an issue is a political question, the Supreme Court is basically saying this is a fight between the executive and legislative branches, and we're not getting involved because it's politics, and Supreme Court's not political. We all know that, right? So, but that's actually a reason the Supreme Court uses to reject certain cases. But like Greg Jacob said in that clip I showed, the long, like over 10-minute clip, that turns it into like a political, that's like a jump ball, and if the courts don't decide it, no one's deciding it, and maybe even decided in the streets, which is kind of what happened on January 6th. Like they tried to use violence and force to overturn the results of a legitimate election, and that's the seditious conspiracy charge that I talked about in an earlier live stream, and I think is going to come up again. Not in the next January 6th committee hearing is this Tuesday, but the Proud Boy seditious conspiracy one is, and the back channel to the president is supposedly going to be revealed in a later January 6th committee hearing. That's where we'll really get into that. But what I'm talking about is this idea that John Eastman knew his argument was bogus and would lose in the Supreme Court 9-0. Oh, I was talking about the whole political question thing and how it would be decided in the streets as a political jump ball. But if it actually did get to the courts, John Eastman, well, first he said 7-2, and that's kind of amusing to me, because when he said that he thought that they would lose 7-2 before he admitted it would be 9-0, I was wondering, who are the two? And of course it's Thomas and Alito. Thomas and Alito would have been the two. Those are the two he must have been thinking of. If you are a follower of the Supreme Court like I am, I believe he was thinking Clarence Thomas, of course, and Alito. And that was some of the breaking news today about how Justice Clarence Thomas's wife, Ginny Thomas, said on some show that she was willing to talk to the January 6th committee, and they've invited her to come in. So that'll be interesting to see under oath if that actually happens, which hasn't been confirmed. But anyway, I think I've pre-introduced, pre-criticized, or pre-described my reaction to the clip long enough, and this is only 47 seconds, much shorter than my introduction of the clip, which I think shows lawyer John Eastman's consciousness of guilt pretty clearly over here.
Even Dr. Eastman knew his theory didn't hold water. Mr. Jacob, you discussed and even debated this theory at length with Dr. Eastman. Did Dr. Eastman ever tell you what he thought the U.S. Supreme Court would do if it had to decide this issue?
Yes. We had an extended discussion, an hour and a half to 2 hours on January 5th. And when I pressed him on the point, I said, John, if the vice president did what you were asking him to do, we would lose 9-0 in the Supreme Court, wouldn't we? And he initially started it, well, I think maybe you would lose only 7-2. And after some further discussion, acknowledged, well, yeah, you're right, we would lose 9-0.
So yeah, that's pretty much clear consciousness of guilt of John Eastman. The clip after next, I think I'm going to show you more of the one part where there's some consciousness of guilt. Wait, is that the right one? Which clip am I on? That was clip number 6. Yeah, I'm going to show you some consciousness of guilt in clip 8. But first, I want to show you, this is a little bit more about the pressure that Trump put on Mike Pence. And this, I almost took my political comedy clip from here. I showed earlier how on January 5th, apparently Donald Trump told Mike Pence, if you don't do this, I'm not going to be your friend anymore, like he's 6 years old or whatever. But here you can see witnesses to Donald Trump's conversation with Mike Pence on the morning of January 6th, after Mike Pence had made clear that he wasn't going to follow through on this bogus conspiracy to obstruct an official proceeding, which is a felony. Mike Pence, to his credit, decided no, he would not commit a felony. So thank you, Mike Pence, for being a vice, being better than Spiro Agnew. Some people are holding up Mike Pence as a hero, and he did stick to principles in this case, but only the principles that made him a better vice president than Spiro Agnew, who actually did commit a felony. So good on you, Mike Pence, for being one of all the other vice presidents who didn't commit felonies. But anyway, I'm getting off on a tangent, and this is Mike Pence being berated and apparently called a wimp and a pussy. And this is as related by members of Trump's family. Ivanka Trump is shown here. But apparently it wasn't just enough to say, I'm not going to be your friend anymore. And then the name calling continued over in this clip.
The president had several family members with him in the Oval that morning for that call. I'd like to show you what they and others told the Select Committee about that call, along with never-before-seen photographs of the president on that call from the National Archives.
When I got in, somebody called me and said that the family and others were in the Oval, and do I want to come up? So I went upstairs.
And who do you recall being in the Oval Office?
Don Jr., Eric, Laura, Kimberly, I believe Meadows was there. At some point, Ivanka came in.
It wasn't a specific, formal discussion. It was very sort of loose and casual.
So then you said at some point there's a telephone conversation between the president and the vice president, is that correct?
Yes.
When I entered the office the second time, he was on the telephone with who I later found out to be was the vice president.
Could you hear the vice president or only hear the president's end?
Only heard the president's end. And at some point it started off as a calmer tone and everything, and then became heated.
The conversation was pretty heated.
I think till it became somewhat, louder tone. I don't think anyone was paying attention to it initially.
Did you hear any part of the phone call, even if just the end that the president was speaking from?
I did, yes.
All right, and what did you hear?
So as I was dropping off the note, I remember hearing the word wimp. Either he called him a wimp. I don't remember if he said, you are a wimp, you'll be a wimp. Wimp is the word I remember.
It's also been reported that the president said to the vice president that something to the effect of, you don't have the courage to make a hard decision.
Words, I don't remember exactly either, but something like that, yeah.
You're
not tough enough to make the call.
It was a different tone than I'd heard him take with the vice president before.
Did Ms. Trump share with you any more details about what had happened, or any details about what had happened in the Oval Office that morning?
That her dad had just had an upsetting conversation with the vice president.
Do you recall anything about her demeanor, either during the meeting or when you encountered her in Dan Scavino's office?
I don't remember specifically. I mean, I think she was uncomfortable over the fact that there was obviously that type of interaction between the two of them.
Something to the effect, the wording's wrong. I made the wrong decision 4 or 5 years ago.
And the word that she relayed to that the president called the vice president, I apologize for being impolite, but do you remember what she said her father called him?
The P word.
So yeah, on the morning of January 6th, apparently there was a phone call in which Trump berated Mike Pence for being a wimp and a pussy, and saying he made the wrong decision when he picked him as vice president, etc., etc. So, I mean, Mike Pence, who had been a very loyal vice president, did stand up to pressure. There was a lot of pressure on him from the president, both directly in conversations like that, and if you watch the entire hearing at the link I put down in the video description, there's a lot more about Trump's speeches and his tweets and all sorts of stuff and sending the crowd to the Capitol, the Hang Mike Pence crowd that came within 40 feet of actually getting Mike Pence. They actually showed this, I don't know, I thought it was a little bit bogus, like this cooperating witness from the Proud Boys says if they had found Mike Pence or Nancy Pelosi, they would have killed them, which, I don't know, that seems like if just the criminal defense attorney in me always wants to cross-examine the confidential informants making speculative claims about what might have happened in some counterfactual universe before accepting it as fact. I'm sorry to that's just an instinct I can't get rid of, even though that was one part of the hearing I didn't like so much. But the one thing, the next couple clips I think show pretty clearly the consciousness of guilt, the criminal intent of the lawyer John Eastman, and this next clip actually includes the strongest proof of Donald Trump's guilt and consciousness of guilt that means that he was corruptly trying to obstruct an official proceeding in violation of 18 U.S.C. 1512 sub c sub 2 that you can see here, which doesn't have the title obstructing an official proceeding. That's a different statute, but that's the best statute. Trust me, as a criminal defense attorney, that's the best statute because courts have already found that the official proceeding, the January 6th qualifies as an official proceeding, and it's a felony punishable by up to 20 years in prison, as I've mentioned many times during my analysis of these of the Capitol insurrection on January 6th. But anyway, I've overintroduced again a clip. This is this is Greg Jacob again talking about a conversation or an email exchange, actually, and so it's all in writing, that he had with John Eastman. This is after the January. This isn't the abstract conversation I've been showing before on January 5th about what what Mike Pence might do. This is after Mike Pence is holed up in some loading dock in the basement of the Capitol or whatever, and the rioters are all over the Capitol. And this is before Mike Pence comes back to certify the votes. I think this is at 11 o'clock Eastern or 11:43 or whatever. Anyway, this is a conversation that Greg Jacob had with John Eastman after it became clear that his whole plan had turned into a violent attack on the Capitol, and he is still trying to get Mike Pence to violate the Electoral Count Act. And somewhere in this exchange, he does admit that he told the president that the whole thing was illegal. And I'll talk about all of that a little more after we watch that clip from the hearings yesterday together over here.
Mr. Jacob, immediately before you and the Vice President were evacuated to a secure location within the Capitol, you hit send on an email to John Eastman explaining why his legal theory about the Vice President's role was wrong. You ended your email by stating that, quote, "Thanks to your bullshit, we are now under siege." We'll take a look at that email. Now, Dr. Eastman replied, and this is hard to believe, but his reply back to you was, "The siege is because you and your boss," presumably referring to the Vice President of the United States, "did not do what was necessary to allow this to be aired in a public way so the American people can see for themselves what happened." Mr. Jacob, later that day you wrote again to Dr. Eastman. Let's show that email on the screen. In that email, you wrote, and I quote, "Did you advise the President that in your professional judgment, the Vice President does not have the power to decide things unilaterally?" And you ended that email saying, "It does not appear that the President ever got the memo." Dr. Eastman then replied, "He's been so advised." And he ends his email with, quote, "But you know him, once he gets something in his head, it's hard to get him to change course," close quote. Mr. Jacob, when Dr. Eastman wrote, "Once he gets something in his head, it's hard to get him to change course," did you understand the "he" in that email to refer to the President of the United States?
I did.
And Mr. Jacob, did you hear from Dr. Eastman further after the riot had been quelled? And if so, what did he ask?
Late that evening, after the joint session had been reconvened, the Vice President had given a statement to the nation saying that violence was not going to win, freedom wins, and that the people were going to get back to doing their work. Later that evening, Mr. Eastman emailed me to point out that, in his view, the Vice President's speech to the nation violated the Electoral Count Act, that the Electoral Count Act had been violated because the debate on Arizona had not been completed in 2 hours. Of course, it couldn't be since there was an intervening riot of several hours. And that the speeches that the majority and minority leaders had been allowed to make also violated the Electoral Count Act because they hadn't been counted against the debate time. And then he implored me, now that we have established that the Electoral Count Act isn't so sacrosanct as you have made it out to be, I implore you one last time, can the Vice President please do what we've been asking him to do these last 2 days? Suspend the joint session, send it back to the states.
And we'll show you the text of that email, which Dr. Eastman wrote at 11:44 p.m. on January 6th. So after the attack on the Capitol and after law enforcement had secured the Capitol, he still wrote, as you described, quote, "So now that the precedent has been set that the Electoral Count Act is not quite so sacrosanct as was previously claimed, I implore you to consider one more relatively minor violation and adjourn for 10 days to allow the legislatures to finish their investigations." So even after the attack on the Capitol had been quelled, Dr. Eastman requested, in writing no less, that the Vice President violate the law by delaying the certification and sending the question back to the states. Is that correct, Mr. Jacob?
It is.
Did you eventually share Dr. Eastman's proposal with Vice President Pence?
Not right at that time, because the Vice President was completing the work that it was his duty to do. But a day or two later, back at the White House, I did show him that final email from Mr. Eastman.
And what was Vice President Pence's reaction when you showed him the email where Dr. Eastman, after the attack on the Capitol, still asked that the Vice President delay certification and send it back to the states?
He said, "That's rubber room stuff."
I'm sorry, Mr. Wood. He said it's rubber room stuff?
Yes, Congressman.
What did you interpret that to mean?
I understood it to mean that after having seen play out what happens when you convince people that there is a decision to be made in the Capitol legitimately about who is to be the president and the consequences of that, that he was still pushing us to do what he had been asking us to do for the previous 2 days, that was certifiably crazy.
We know that the Vice President did not do what Dr. Eastman requested because he presided over the completion of the counting of electoral votes late in that evening.
The number of electors appointed to vote for President of the United States is 538. Within that whole number, a majority is 270. The votes for President of the United States are as follows. Joseph R. Biden, Jr. of the state of Delaware has received 306 votes. Donald J. Trump of the state of Florida has received 232 votes. The whole number of electors appointed to vote for Vice President of the United States is 538. Within that whole number, a majority is 270. The votes for Vice President of the United States are as follows. Kamala Harris of the state of California has received 306 votes. Michael R. Pence of the state of Indiana has received 232 votes. The announcement of the state of the vote by the President of the Senate shall be deemed a sufficient declaration of the persons elected President and Vice President of the United States, each for the term beginning on the 20th day of January, 2021, and shall be entered together with the list of the votes on the journals of the Senate and the House of Representatives.
So yeah, that was like the climax there where Mike Pence did not succumb to the pressure, did not commit the felony, but you saw extensive evidence there that John Eastman knew he was committing a felony. He put in writing that he still wanted Mike Pence to violate the Electoral Count Act, even though there is nothing in the 12th Amendment that gives the Vice President, the only way you can violate a federal law without it being illegal is if you're saying something in the Constitution makes that federal law unconstitutional. But where is it in the 12th Amendment that the Vice President gets the power to decide the election? Nowhere. So not only did he admit that, but he also said in writing to Greg Jacob that he conveyed the illegality of the plan to the president. So the president knew it was illegal, but then he says, well, but Trump, once he gets something in his head, it's hard to get him to change course. But that kind of goes back to the argument I was making in my last live stream on Tuesday regarding whether Trump knew he lost the 2020 election and lied about it. And, there's the one thing where he did know and he was consciously lying about it. And then the other, he's delusional and doesn't know. But then I had this third possibility, which I think may apply here, where he's, I don't want to, do a psychological diagnosis, but kind of he's a sociopath or he has a broken personality, I was saying on Tuesday, where whatever it is that's wrong with him, he just, when he thinks about what he's going to say, whether it's true or not, doesn't factor in. He doesn't care whether something's true or not. It's only, does this help him or does this not help him? He's looking for things to say that help him, and whether they're true or not does not matter to him. And as I said, as a criminal defense attorney, the fact that you don't have to lie to be guilty of having corrupt intent under 18 U.S.C. 1512 sub c sub 2. That means you have to act corruptly, have to have corrupt intent. If you have a broken personality where you don't care what's true, that is also corrupt intent. And I think that may also be true here, where where John Eastman is saying he told Trump that this whole thing was illegal, but Trump didn't care, and he got it in his head that Pence could do this, and it was hard to get him to change course. And one of the things that could happen is John Eastman could be prosecuted, and he could flip on Trump and give more details about how he was very he was very clear with Trump that this was illegal, but Trump wanted to go ahead anyway, or whatever. Or, I mean, that's the kind of thing. In order to get credit for cooperating, he would have to give those kind of details, I guess. And if you want to see evidence that John Eastman knows he is having some kind of criminal problem, that he is in criminal trouble for what he did regarding January 6th, that he was part of this whole conspiracy to obstruct an official proceeding. And I haven't even talked about this other possible felony, defrauding the U.S. government, but maybe that'll be for another show. But I want to show you some of the clearest evidence. This is John Eastman getting a call from Eric Hirschman, White House counsel, where this is on January 7th, after the whole January 6th debacle, where he's like asking for advice on something going on in the Georgia recount or something. And Eric Hirschman, who I think you saw in one of the previous clips, said, dude, I don't even want to hear anything but 2 words from you. 2 words. I'm not going to tell you what the 2 words are. And then he gives him like legal advice at the end that is like so awesome. This is like the cherry on top, or what is it the kids say? The chef's kiss. The chef's kiss here on John Eastman's consciousness of guilt in the final clip from the hearings yesterday. I'm going to share with you over here.
The day after, Eastman, I don't remember why he called me, or he texted me or called me, wanted to talk with me, and he said he couldn't reach others. And he started to ask me about something dealing with Georgia and preserving something potentially for appeal. And I said to him, "Are you out of your effing mind?" Right? I said, I only want to hear 2 words coming out of your mouth from now on. Orderly transition. And I screamed, I said, I don't want to hear any other effing words coming out of your mouth, no matter what, other than orderly transition. Repeat those words to me. And I screamed that. Eventually he said, orderly transition. I said, good, John. Now I'm going to give you the best free legal advice you're ever getting in your life. Get a great effing criminal defense lawyer. You're going to need it. And then I hung up on him.
In fact, just a few days later, Dr. Eastman emailed Rudy Giuliani and requested that he be included on a list of potential recipients of a presidential pardon. Dr. Eastman's email stated, quote, "I've decided that I should be on the pardon list, if that is still in the works." Dr. Eastman did not receive his presidential pardon. So let's see what Dr. Eastman did as a result when he was deposed by this committee.
I assert my Fifth Amendment right against being compelled to be a witness against myself.
Did the Trump legal team ask you to prepare a memorandum regarding the vice president's role in the counting of electoral votes at the joint session of Congress on January 6, 2021?
Yeah.
Dr. Eastman, did you advise the President of the United States that the Vice President could reject electors from 7 states and declare that the President had been reelected?
Yeah.
Dr. Eastman, the first sentence of the memo starts off by saying 7 states have transmitted dual slates of electors to the President of the Senate. Is that statement in this memo true?
Yeah.
Did President Trump authorize you to discuss publicly your January 4th, 2021 conversation with him?
Fifth.
So is it your position that you can discuss in the media direct conversations you had with the President of the United States, but you will not discuss those same conversations with this committee?
Fifth.
So, yeah, Eric Hirschman advised John Eastman on January 7th that, well, you've got to be effing kidding me. You just need to say the words orderly transition and get yourself a good criminal defense attorney. I don't know if he has or not, but he, well, you saw late, well, you saw, I'd like to be on that pardon list if that's still in the works. That was a lot of people made memes out of that yesterday that were pretty amusing. And then you saw him taking the Fifth Amendment over and over again with his criminal defense attorney. I do want to thank all the people who joined me for this live stream, and especially my regular viewers. And I saw Lulu Girl gave 2 super chat contributions, which I especially appreciate. And that's kind of a weird idea that because I noticed I have a bunch of extra viewers today, and are like half my viewers muting the other half of my viewers, so you're like living in 2 like alternate universes, like people who watch Fox News and people who watch MSNBC, and you're like each watching my show without hearing well, I don't know. And then of course Lulu Girl did mention my cat Dash, and Dash is for a long time in my live streams, I've been ending my show with the bonus Dash and Sandy clips, my cat Dash and my dog Sandy, or the Dandy clips as we were calling them for years. And Sandy died in February at the age of 11, and that was very sad. And last November I talked about how Dash had gotten really sick. He had pancreas disease and heart disease and kidney disease, and he just turned 17 a week ago on June 9th, and so he was an old cat, but he had like a long good life. And last November there was like a couple weeks where he stopped eating and looked like he was going to die, and we took him to the vet, and we got like some steroids and antibiotics and gave those to him for a while. And by the beginning of December he like made this miraculous recovery, and we got like an extra 7 months of a happy, active Dash cat. And then just in the last week or so he started losing weight, and starting like Sunday he stopped eating and he was throwing up. And Monday, and I think I talked about how we called our veterinarian. We never heard back from our vet. Back in November we were told he was an end of life, and I told you about all of his diseases, so we wanted to have minimum interventions, and all we wanted to do was like retry the steroids and the antibiotics we tried in November. And then we realized we had some left over, so like Wednesday we started trying to use the steroids. But he stopped peeing a couple days ago. He stopped drinking I think on Wednesday. And Thursday, yesterday, he couldn't even sit up. He was lying on his side. This, like the final Dash clip I'm going to show you here is from the beginning of this January 6th committee hearing. This was like 10 a.m. Pacific time. This is about maybe 7 or 8 hours before Dash died. He was just like lying on his side, like breathing, and like you'll see like his head move slightly. This is the beginning of the January 6th committee hearing yesterday, the final Dash clip over here.
The Select Committee to investigate the January 6th attack on the United States Capitol will be in order. Without objection, the chair is authorized to declare the committee in recess at any point. Pursuant to House Deposition Authority Regulation 10, the chair announces the committee's approval to release the deposition material represented during today's hearing. Good afternoon. This is almost no idea more un-American.
So yeah, just during the course of the day, he just had less and less energy, and eventually he stopped breathing, and about 7 or 8 hours after that, he just passed away. And I don't want to go into the details of those last 45 minutes that weren't very pleasant, but other than that, he had a long, good life, and he was 17 years old, and I'd rather remember him. This is a picture I put up on LiberalViewer, the youtube.com/LiberalViewer channel tab, where you go to Community tab. This is a picture of Dash just from less than a year ago. This is July 2021. Sitting on, you can see that's like a Star Trek towel that I put over this chair that he used to sit on, and that was before he started losing weight and happier times. And anyway, I have not had no pets since 1998, and that was only for a few months. I went between cats in 1998. That was between my cat Dershowitz and my cat Zimbra, and Zimbra overlapped with Dash, and Dash is my longest living cat. I don't know. I think we might wait a few months. Dash did not use the litter box for the last several years of his life. He's destroyed a few different rooms. We have to replace carpets and stuff. There are at least 3 rooms in the house that have strange cat urine spots. But I don't know. I've always had pets. Like I said, this is the first time I haven't had a pet since 1998. And that was only for a few months. Before that, you have to go back to 1992 or something. So maybe in a few months after we fix up the house, I'll get a kitten, maybe? I don't know. Before the November elections, while I'm still doing this live stream. But anyway, I appreciate all the condolence messages I got when I put up that picture of Dash over on my over at youtube.com/LiberalViewer. I think I've already gotten over 20 condolence messages, and I know there were a lot of Dash and Sandy fans, the Dandy fans out there, and Sandy died in February and Dash died yesterday, and it's, what can I do? It's a sad occurrence, and I should probably end the live stream before I start crying, but I appreciate all of you and who showed up. Oh, and I see that I'm getting another, I see the Real Folk Blues 316 gave me a super chat contribution, and Lulu Girl and Tom Trask thanking me for the memories for Dash. And that is the story of how there's no more Dash. And I will be back on Monday for the Juneteenth federal holiday to do my Monday media mix-up. And then there's going to be another January 6th committee hearing on how Trump tried to change the acting attorney general and only was stopped by the possibility of mass resignations to institute his coup plot or whatever. And I don't know, I'll see what the evidence is on that on Tuesday. And yesterday I had been planning to do this live stream yesterday. I probably could have put it all together by the end of the day yesterday, but the death of Dash made that impossible. And I don't know, maybe I'll be able to do a same day live stream on Tuesday. Otherwise, it'll be Wednesday morning or whatever. But anyway, I will be back next Monday and for the next January 6th committee hearing. And until then, I guess I will be seeing all of you around the internet.